Jury charge practice at 180 words per minute on the record. Ladies and gentlemen of the jury, now that you have heard all of the evidence and the arguments of counsel, it becomes my duty to give you the instructions of the court concerning the law which governs this case. It is your duty as jurors to follow the law as I shall state it to you and to apply that law to the facts as you find them from the evidence presented in court. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law stated by me, regardless of any opinion you may have as to what the law is or ought to be. It would be a violation of your sworn duty to base a verdict upon any view of the law other than that given in the instructions of the court, just as it would also be a violation of your sworn duty as judges of the facts to base a verdict upon anything other than the evidence presented during the trial. On the record at 180 words per minute. On the record.
Ladies and gentlemen of the jury, I'll give you my instructions, which you should consider when you are deliberating. You are to decide this case only from the evidence which was presented at this trial. You are to consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give any evidence in making your decision. You must consider all of the evidence in light of reason, experience, and common sense. There may be discrepancies or differences within a witness's testimony or between the testimony of different witnesses. This does not necessarily mean that a witness should be disbelieved. Sometimes when two people observe an event, they will see or hear it differently. Sometimes a witness may have a lapse of memory. Witnesses may testify honestly, but simply may be wrong about what they thought they saw or remembered. You should consider whether a discrepancy relates to an important fact or only to an unimportant detail. Usually, witnesses are not permitted to testify as to opinions or to conclusions. However, a witness who has scientific, technical, or other specialized knowledge, skill, experience, training, or education may be permitted to give testimony in the form of opinions. Those witnesses are often referred to as expert witnesses. You may remember that Joe Brown came in and was qualified as an expert in firearms. You should determine the weight that should be given to an expert opinion. You should consider the education, qualification, and experience of the witness, and the credibility of the witness and the facts relied upon by the witness to support the opinion and the reasoning used by the witness to arrive at the opinion. You should consider each expert witness and give it the weight, if any, that you think it deserves. You are not required to accept the opinion of any expert. The defendant in this case is accused of conspiracy. Conspiracy is an agreement to perform an illegal act. In order to establish an action for civil conspiracy, there must be a combination between two or more persons to accomplish by concert an unlawful purpose or to accomplish a purpose not in itself unlawful by unlawful means. In connection with concerted action, it is not essential that each conspirator had knowledge of all the details of the conspiracy, but there must be an overt act. When this act occurs, it is not necessary that the party is aware of the nature of the harm to be done or the person against whom the harm will be done. It is not a defense that someone else may have played a greater part than another. Neither is it your responsibility to identify other co-conspirators if you find that they do exist. It is no defense that someone else might have played a role or possibly a greater role than the defendant. In this action, the plaintiff has the burden of establishing by a preponderance of evidence all of the facts necessary to prove the following issue. That is, that the defendant conspired with others who are not parties to this action to commit an act which resulted in the harm of the victim. The term preponderance of the evidence means that amount of evidence that causes you to conclude that an allegation is probably true. To prove an allegation by a preponderance of evidence, a party must convince you that the allegation is more likely true than not true. If the evidence on a particular issue is equally balanced, that issue has not been proved by a preponderance of the evidence, and the party has the burden of proving that issue. The party that has the burden of proving that issue has failed. You must consider all of the evidence on each issue. A stipulation is an agreement. If the parties have stipulated that certain matters of fact are true, they are bound by this, if they so stipulate. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. The parties have stipulated that should you find that they are entitled to recover in this case, that the dollar amount should not exceed $100. A verdict form has been prepared for you. After you have reached unanimous agreement on a verdict, your foreperson should complete the verdict form according to your deliberations. Sign and date it. Advise the clerk that you are ready to return to the courtroom. At this point, I will give you an additional instruction. By giving an additional instruction at this time, I do not mean to emphasize this instruction over any other instruction. You are not to attach undue importance to the fact that this instruction was read separately to you. You must consider this instruction together with all of the other instructions that were given to you. I remind you that in your deliberations, you are to consider the instructions I have given you as a whole. You should not single out any part of any instruction, including this one, and ignore others. They are all equally important. You may now return to the jury room and continue your deliberations.